right, so welcome to panel 2, everybody.
Feel free to ignore it.
Third panel of the day is actually number 2. As before, we're going to have 2 papers and 2 commentaries. First paper will be by Michael Greavy, who will be commented on by Artie Rye, joining us remotely. And then Emily Bremer will give the second paper, followed by Jay Keeson. And with that, I will turn it over to Michael.
Oh, that was quick. Thank you.
We're already a little behind, so I need to get it going.
Okay, I'll talk faster. I'll do my best. Richard Epstein imitation. I suppose I should thank Adam Mossoff, sort of, for getting me into this. I do want to say special thanks to Professor Rye for commenting on this paper. I'm pretty sure it contains a bunch of sort of sloppy mistakes and errors of judgment. I know nothing about patent law. I mean to keep it that way. And I haven't had time to look everything up that I wanted to look up, so I'm genuinely looking forward to the corrections to come. This paper is mostly addressed to administrative law scholars, and it addresses a fairly narrow, but I hope somewhat intriguing questions. There's been, as you all know much better than I do, a lot of agitation, litigation over the coordination between Article 3 infringement proceedings and PTAB review and re-examinations. And so one of the key questions there, obviously, is whether patents can be canceled administratively, even if the patentee has previously prevailed in an infringement proceeding. The Federal Circuit's answer to that question is, by and large, yes, subject to a very narrow exception for absolute finality, which sort of bars very little except maybe disgorgement of damages a patent holder may have obtained. I'm not sure the Federal Circuit's position there is right. I think many of the opinions on the question are a bit of an embarrassment, but for purposes at hand, I'm leaving this to CIFPO experts who know much more about claim and issue preclusion than I do. The somewhat related question that this is about was suggested by John Duffy in our earlier workshop, and it's this: suppose somebody obtains a patent not from the PTO originally, but in a Section 145, Article 3 proceeding. Can that patent then be canceled in a re-examination proceeding? And my answer to that question is no. You cannot conclusively establish patent validity in an infringement case. Obviously, that's why subsequent PTAB cancellations may be constitutional, but you can establish patentability in a 145 proceeding. In fact, that's the point of it. And I think the PTO and PTAB cannot make that final Article 3 judgment subject to executive revision. I think Haber's case and Plout versus Spendthrift Farms have to mean at least that much. There may be 2 ways of avoiding the conclusion. One might argue that PTAB cancellations can then be further appealed to the Federal Circuit. That doesn't do it for me for all sorts of reasons. The other avenue is to say, well, you might think that Section 145 isn't really an original civil action and a final judicial determination. It's just an appeal and review of an administrative patent denial. So a determination of patentability in those kinds of proceedings under Section 145 is just a remand to the agency. Something like that seems to be the PTO's position, but I think it's affirmatively foreclosed by the Supreme Court's decision in Kappas versus Hyatt. Technically, that decision just governs rules of evidence in Section 145 proceedings, but the court unequivocally rejected the PTO's position that the proceedings under Section 145 should be understood in accordance with administrative law principles, sort of as a slightly modified administrative appeal. And Section 145 determination is not a remand to the agency. It's a conclusive determination of the rights between the parties, and the award of the patent, upon payment of the applicable fee, is simply a ministerial act, I think. and the Article 3 judgment can't be subject to revision. Again, that's a narrow question, certainly in a practical sense. There aren't that many Section 145 proceedings to begin with. They're too expensive. I have no idea whether the cancellation question that I just addressed will actually arise in real life. The reasons why I find it interesting have nothing to do with patents. They have everything to do with administrative law. So this paper is, as the title says, a view from the periphery in two respects. One, to repeat, I'm an outsider to patent law. And two, the scholars who argue for patent exceptionalism, several of them in this room, have a great deal of confidence in the integrity and stability of administrative law, not the APA, which is a statute in exile, but the sort of administrative common law of Chevron and sort of expert agency models and so forth. I myself don't have that confidence, and I deem myself in good and plentiful company. I actually don't see how anyone can follow the administrative law debate that's raging in the law reviews and not conclude that it's a disaster area and a construction zone, right? So Gary Lawson and Philip Hamburger and Adrian Vermeule all argue that there's no law here at all. They just disagree as to whether that's a good or bad thing. But you don't have to sort of go to those extremists. You just look at the titles of law review articles, right? End the failed Chevron experiment. Bureaucracy at the boundary, unorthodox lawmaking, unorthodox rulemaking, the lost world of administrative law without Congress for that matter, all come with hundreds of SSRN downloads and citations, right? It seems to me if you do not want patent exceptionalism, quote unquote, you have to explain what exactly it is you want to normalize patent law to, and that is no longer a given. So in that light, I think it may be useful, or at least also useful, to ask sort of what the confused administrative law debate can learn from patent administration. John Duffy asked and answered that question in a terrific article many years ago, favorably contrasting the PTO with the heroic agency model of the Federal Communications Commission, and God help us. Right, this is a much more, or a somewhat more doctrinal riff on the same theme, very narrowly focused on the judicial review provisions of the Patent Act, and so here's the gist of it. The patent lawyers among you can now go to sleep because all of this is ad law. So everyone agrees that Section 145, as it's been interpreted in the Hyatt decision, is totally inconsistent with the administrative law framework of judicial deference and agency expertise. So what do you learn from that? One thing I think administrative lawyers can learn from this is to liberate the administrative law debate from its dreadful Chevron-induced hang-up and hangover, this preoccupation with pre-enforcement review and rulemaking proceedings. That'll never be more than an interest group sport. Everybody will always get deference, and that's theater. I think there's much more sort of constitutional and rule of law substance in adjudication, which is about whether this agency can do that thing to you in particular. We used to call that question a question of private right. We don't anymore. For good or ill, as the late Justice Scalia wrote, this stuff is governed by Kroll versus Benson, which says that private rights can be committed to administrative adjudication in the first instance, subject to deferential review. The Kroll court insisted on various safeguards to protect private rights in appellate review, but all those have gone by the boards more or less, first on account of a public rights exception that chews up private rights, and second, because the surrogate safeguards for rights remain that sort of aren't all that convincing. So Adrian Vermeule has argued that this had to happen once you allow deference into the system. Law will give way, and all the legal distinctions that used to protect private rights will collapse, and I think Adrian is right about that. A patent review is different by statute, right? So Kroll tried to harmonize private rights and public administration under a single model of appellate review, and the Patent Act splits the two. You can contest an adverse patent decision in one of two ways. You can have a full-scale de novo Article 3 determination under Section 145. It's expensive, it's time-consuming, but it's an independent determination of private right. Or you can have an appellate review proceeding under Section 141 in the Federal Circuit. That's relatively cheap and prompt, but it's also deferential and therefore biased against you. It's not a terribly attractive choice, but the point is, it is your choice. The administrative appeal is a waiver of right. They can't just throw you under the administrative bus. So in that structural sense, the private rights model there dominates the system. What's the takeaway? There's no deep constitutional point here or patents as rights point. Sorry, Adam. Congress could wipe out Section 145 in a heartbeat and do to patent applicants what it does to every other citizen, which is beg for mercy. I don't have a profound institutional reform point either. I don't know whether other administrative regimes might lend themselves to de novo judicial proceedings at the applicant's choice. German administrative law, which I learned in my ill-spent youth, works on the principle of full-scale de novo adjudication, but you can't easily import that. So my humble point is simply this. The proposition that rights don't really matter is the central proposition of the APA and of administrative law. Right? The world is a common pool of values and interests, and what review you get depends on the form of administrative action and not on the substance. And that rights neutrality is supposed to be an accomplishment. I think it's a pathology, and in fact, the central pathology of administrative law. If you want to rethink this body of law, I think that's where you have to start. Patents are admittedly a somewhat weird place to start that debate and preoccupation with or reorientation toward private right, because ultimately they come from statute, but at least the statutory review regime recognizes the difference between rights and appellate review, between Marbury and the administrative state. And the Supreme Court in Hyatt has affirmed that regime. That's an opportunity, I think, to relearn some long forgotten but important legal distinctions. That may not be an awful lot, but every little bit counts.
All right, thank you, Michael. Artie, if you can hear us, you can get started with your commentary.
Wonderful. I hope everyone can hear me, and I apologize for not being able to be there in person. We are currently at Duke Law School undergoing a dean search, and so many things have popped up in my schedule as a consequence. So first, thanks to Adam for providing me the opportunity to comment on this very interesting paper, and thanks to Professor Greavy for writing it. I thoroughly enjoyed reading it. I think it's fair to say that Professor Greavy provides a really elegant intellectual history, eloquently using the lens of a seemingly insignificant detail, Section 145, to draw attention to the complex ways in which patent law still bears, and I think in a salutary fashion from Professor Greavy's perspective, a significant 19th and early 20th century imprint. And so as a huge fan of Milan Kundera, I loved the quote regarding the cap on Gottwald's head. This is the cap on Gottwald's head that reminds us of what law used to be, perhaps. I would quote Faulkner and say, you know, the past is never dead. It's not even past, particularly in patent law. So I'd like to address both this rich exercise in intellectual history and the seemingly insignificant detail, which I agree, actually, I say, notwithstanding Professor Greavy's modesty, may be far from insignificant in the long term. So first, the intellectual history. I agree with Professor Greavy that the intersection between patent law and administrative law is complex, and I also agree that administrative law is far from a pristine and unified enterprise. It has no grand unified theory, and I would hope that no one would, to use a term that Professor Greavy uses in his paper, want to be an administrative law imperialist, quote unquote. And I hope I'm not an imperialist in this regard. I would certainly disavow being one. In fact, the paper that I wrote a long time ago now, 10 years ago, with Professor Benjamin, that perhaps started some of this recent debate on the intersection of patent law and administrative law, states that point fairly explicitly. So we state fairly explicitly that we're dealing in a world of not of ideal law, but of the best understanding we can reach of what administrative law seemed to be circa 2007. We explicitly disavow any attempt to undertake ideal law. And so that's the framework in which I initially kind of started to explore this set of questions. And I think it's fair to say that even now I have more than the quote next to zero faith unquote in the administrative law enterprise that Professor Greavy has or lacks. But nonetheless, I think that, it is a far from ideal area of law, and perhaps between 2007 and 2017, it's become even more fractured. In fact, I'll speak to that in just a moment. But before I get to that, more specifically, I think on the patent aspect of it, here's where Professor Greavy and I may diverge a little bit. First and foremost, I think one set of actors that is missing in Professor Greavy's very robust and excellent intellectual history is the empirically oriented economist. So I think that it's fair to say that the idea for substantially enhancing the role of the administrative state through some sort of robust post-grant review proceeding came not from lawyers, but from empirically oriented economists. So Bronwyn Hall, who is sort of a giant in the world of patent economics, Stuart Graham, who is also, in my view, a giant, I believe is in the audience as well. They observed back in the early aughts that the post-grant review system in Europe appeared to be functioning efficiently, and they thought that a similar system might work here as well. The National Academy of Sciences committee that recommended post-grant review was chaired by a renowned economist who was then president of Yale University, Richard Levin. So Professor Greavy may be no more enamored of economists and empirical economists than he is of administrative law enthusiasts, but I think that it's fair to at least include them in the cast of characters. What some of us then did as law professors was start thinking about how this idea might work in the unique American administrative law context. Obviously, Europe is a very different arena than the US, and comparative administrative law is a rich field in and of itself. So it provided some of us fodder for thought. And just as a matter of first principles, and the economists obviously made this clear in their modeling of a potential post-grant review system, if efficiency gains were to be achieved, they were not going to be achieved by a system that addressed the whole set of issues again de novo in the courts. That was, a fairly obvious point that one didn't have to be an empirical economist to understand. So perhaps not surprisingly, under the AIA, the various mechanisms for reviewing a patent post-grant result only in a conventional appeal, not a Section 145 type action. So that's a cast of characters I would definitely include in any intellectual history of how we became a little more administrative law oriented in the patent legal academy. I don't think I would have gone there had it not been for the empirical economists. Now, what the Congress ultimately did in setting up the AIA looks fairly different from what the National Academies recommended. We know how legislation and sausage are made, and neither of them is pretty. And so I think that there are lots of ways in which one could have set up the institution differently, and the PTAB is struggling as well in setting up appropriate rules for itself, particularly for purposes of guarding against harassment. The courts have struggled as well, and here I agree with Professor Greavy that the lack of finality created by the Federal Circuit's mechanisms for trying to address these dual proceedings is far from optimal. So I think that is an area for significant improvement. That said, I don't think any of these points call into question the idea of administrative error correction, and I'd be happy to go further into the economic case for administrative error correction in the Q&A. So last point of intellectual history, and this is on administrative law, qua administrative law. So I don't pretend to be as nearly as erudite a administrative law scholar as Professor Greavy, but I would say one thing is I do teach administrative law and have taught it for the last 10, 15 years or so. I would argue that once upon a time, it seemed that positions on questions of administrative law appeared to have a little bit less of an ideological valence than perhaps they have now. So Justice Thomas wrote the Brand X case, which is the ultimate kind of Chevron on steroids case. And of course, Justice Scalia himself was very closely associated with Chevron. Justice Scalia wrote the Auer case, which has probably come in for even more criticism than Chevron itself. So to the extent it seems to be an ideological tendency to think the administrative state is either illegitimate or certainly overextended, it wasn't always associated with a particular shall we say, political persuasion. Meanwhile, Justice Brennan, together with Marshall, Blackmun, and Stevens, was the Article III enthusiast who wrote Northern Pipeline versus Marathon. So I do think it's a little bit peculiar that administrative law circa 2017 has gotten thrust into a type of polarized discussion. All right. Finally, I would argue, and this is just a small point, and I have argued that I would agree that notice and comment rulemaking is the much better way to do policy, much superior to adjudication. I don't think that's a controversial point. I simply don't think that for the time being, the PTO is in any realistic way likely to get it. Of course, it has gotten it to some extent in the AIA for what might be called post-grant review related material, and that issue is very much a question at Aqua Products, which we can discuss in the Q&A if necessary, but that's just a small point on the intellectual history question. Now on section 145. Here I think, even by Professor Greavy's account, the history is less intellectual history than just history. In other words, section 145 is a somewhat accidental remnant of a prior 19th century vision of the world. And I really commend Professor Greavy for his frank acknowledgement that he'd hoped to find, but did not find, that Congress in any way deliberately chose the 145 process as a private law alternative when it enacted the 1927 patent statute. I think that's a remarkably candid and a wonderful observation, very interesting in terms of some of these polarized debates that we have on private law versus public law. Another point on section 145, excuse me, that's worth making that I hope will transcend some of the more polarized debates. In the discussion of post-grant review that led to the AIA, some of us argued that, in point of fact, perennial post-grant review for some patents was really a bad idea, and that entities should be able to elect out of it through certain voluntary mechanisms. So in the 2007 article, I argued for self-selection into a more rigorous administrative review that would subsequently be treated very deferentially by the courts, or even not even reviewed in any meaningful way by the courts. Professors Lemley and colleagues talked about so-called gold-plated patents that wouldn't be subject to post-grant review. That was a very similar proposition. Now, as it happens, because of a variety of decisions by the Supreme Court, in particular Microsoft versus I4I, it seems that all patents, at least in courts, are gold-plated. They're all subject to a clear and convincing evidence requirement on the part of the challenger. So it's only in post-grant review that they're not gold-plated, and so there's obviously no incentive to go through rigorous review at the PTO if you're going to get a gold-plated patent vis-a-vis the courts anyway. But perhaps given the popularity of post-grant review, this would be another way of getting a gold-plated patent, not through the administrative process, but through something of a 19th century non-administrative mechanism. Not sure it's my preferred route, but at least it's a court proceeding, I think, that would not involve juries in any way, which is, I think, universally agreed within the legal academy to be an institution to be avoided if possible. It's expensive, and there's some reason to believe under the Federal Circuit's current jurisprudence that the Section 145 mechanism would require the applicant to pay not only their own fees, but also the PTO fees. And there is reason to believe that's justifiable as well, but we can talk about that. So I agree that Section 145 is actually very intriguing and far from inconsequential. It could be the way that we get gold-plated patents. All that said, and this is my concluding point, I'm not sure it can or should bear all of the weight of history. I think the burden or benefit of history, depending on one's perspective, is clear not only in Section 145, but in much of the Supreme Court's recent jurisprudence, hence the title of a recent article I wrote about patent law stare decisis. I think Microsoft versus I4I, which relies on a pre-APA case, is an example. Perhaps the most visible examples are the court's recent cases on patent-eligible subject matter, which also go back to the early 20th century and to some extent the 19th century. You know, on the other hand, of course, we do have cases more perhaps amenable to the administrative point of view, like Quozo versus Lee. So I don't think we can draw any general conclusions. The empiricist in me says the sample size is simply too small and the decision's too bizarre and erratic. So I wouldn't purport, notwithstanding the 2016 article, to draw any general conclusions. So I, for example, would not make any predictions on how Professor Greavy's approach to using Section 145 would be treated in a successor to the Kapos versus Hyatt case, although I think that Professor Greavy has a very interesting and important argument. And certainly I will not make any predictions on oil states, even though I think Professor Greavy thinks that that's, after Kroll versus Benson, clearly can only be decided in one way. I'm not so sure, because it does seem that administrative law, again, even more so in the last 10 years, much to my regret, has fallen into the general polarization into which so many of our debates in law have fallen. I really enjoyed the opportunity for this paper and to comment on this paper, and I look forward to your questions.
Excellent, thank you. So Emily, I believe your paper is next. If you want to get started on that, we'll save all questions for the end.
Okay, good afternoon. And I'll add my thanks to the organizers. It has been such a joy to participate in this, and the papers that have been put together are really great. So I come at this from an administrative law perspective as well. And in fact, before I went into academia, I spent 5 years working for the Administrative Conference of the United States. So I am much in Professor Walker's camp in the sense of being a really thoroughly unabashed proceduralist and administrative procedure geek. So the paper that I have contributed looks at PTAB proceedings, and in particular inter partes review proceedings, and asks basically two questions. The first question, the legal question the paper addresses, is, are inter partes review proceedings formal adjudications? And the second question is less of a legal question. From an administrative law perspective, are these proceedings weird? Are they strange? Are they really a platypus? And I think the answer to the first question, or at least the analysis of the first question, maybe can shed some light on the second. So with respect to this first question of whether or not inter partes review proceedings are formal adjudications, the law offers not one, not two, but at least three distinct legal tests for defining what constitutes a formal adjudication. And stranger still, as applied to inter partes review proceedings, those three tests yield at least three different answers, and arguably four. And so through this analysis, the conclusion that I come to is that no, inter partes review proceedings are really not weird from an administrative law perspective, because in administrative adjudication, exceptionalism is the norm. So I'll sort of walk through the three and speak a little bit more about the implications of the analysis. So the first of the three approaches to answering the question, what is a formal adjudication, is what I refer to in the paper as the de novo APA approach. Traditionally, when we speak of formal adjudication, we mean adjudication conducted under sections 554, 556, and 557 of the Administrative Procedure Act. Well, there is one line of cases that says, an adjudication is a formal adjudication when it is subject to adjudication under those provisions of the APA. And what that means is that the APA is actually the source of procedural law. Right, so you look at section 554, which contains in it what's known as triggering language, which specifies the proceedings to which the APA's adjudication provisions will apply. And it says that it applies in every case of adjudication required by statute to be determined on the record after opportunity for agency hearing. And so one of the strongest cases that uses a sort of de novo application of that standard for determining whether an adjudication is formal is the Supreme Court's 1950 decision in Wong Yang Sung, where it held that deportation proceedings were required to be adjudicated under the APA. Now, I'll just drop a footnote and note that Congress almost immediately overturned that decision by statute and made very clear by statute that it did not want those proceedings to be conducted under the APA. Now, in more modern terms, the only cases in which this de novo APA approach is applied involves cases where there's a claim for payment under the Equal Access to Justice Act, which is basically an administrative fee-shifting statute. And it operates as a waiver of sovereign immunity. It requires an agency to pay costs and fees to a prevailing party in certain administrative adjudications. And the language makes very clear that an adjudication is defined as a proceeding that's conducted under Section 554. Now, perhaps because they're interpreting this as a waiver of sovereign immunity, the courts have interpreted it strictly and have said that it's unambiguous what that means, and that lack of ambiguity seems to flow through the analysis to Section 554 itself, such that the courts are very clear about, well, is this a statute, is this a proceeding that's required by statute to be determined on the record after opportunity for agency hearing? And the court does that analysis itself without taking into account what the agency's view is of its own statute, which of course in administrative law these days is something of an aberration. Now, under this approach, I think it's very clear that inter partes review proceedings are not formal adjudications. There is no indication in the statute that Congress had the Administrative Procedure Act in mind. There's no reference to the adjudication provisions of the Administrative Procedure Act. There's no magical language on the record. And in fact, to the contrary, it appears that what Congress was trying to do in the AIA was to create a very specific, albeit very trial-like, proceeding which really kind of looks at district court litigation and seeks to tailor those procedures for an administrative tribunal. So under that first approach, I think you can say pretty clearly, no, inter partes review proceedings are not formal. Now, the second approach to defining proceedings as formal adjudications is what I refer to in the paper as the agency procedural discretion perspective. This is basically the same analysis. The APA is still sort of at the core of what we're concerned about, but it's not necessarily the source of law, and the analysis is significantly softened by the familiar overlay of attention to and sort of respect for agency discretion. Agency discretion in terms of interpreting its own statute, and agency discretion to craft its own adjudicatory procedures. And here's where you get potentially two possible answers. And I think that the best answer, and by the way, the reason you get two answers is there's two ways to ask the question here. The agency procedural discretion perspective most often arises where someone sues in court and says, agency, you're required to adjudicate under the APA, and you didn't. And so the question for the court is, do I have to compel the agency to adjudicate under the APA? In those circumstances, courts really only compel an agency to conduct APA adjudication if the magic words on the record appear in the agency's statute. If there's not a hearing on the record required by statute, or the provisions of the APA aren't specifically identified, then courts don't compel the agency to adjudicate under the APA. And again, for the reasons I already identified, I think it's very clear that from that perspective, under this approach, you would say, no, the agency is not compelled to comply with the APA's provisions. So it's not formal. Now, the flip side of that is there are circumstances, much rare and very rarely, if ever litigated, where an agency voluntarily decides to adhere to the APA's procedures, despite the fact that it's not statutorily required to do so. Now, as a practical matter, it's hard to come up with a situation where the PTO might make that decision. An example of a situation where an agency might is where it decides it wants to use administrative law judges voluntarily in its proceedings, in which case it's going to have to prove to OPM that its hearings are required either by statute or by the agency's own regulations to be conducted in accord with the procedures that are established in the APA. Now here, formal is defined using the APA not as a source of procedural law, but really as a template for describing the various characteristics that make up a formal adjudication. Now, maybe the PTO, because of a strong norm in favor of agency procedural discretion, could make a claim that its procedures are formal in that sense. It's just difficult to identify a circumstance or a reason why the agency would do that. Now, the third and final approach to defining adjudicative formality comes from the case law defining the circumstances in which courts will give Chevron deference to an agency determination. Now here the APA can be relevant, but it's not the source of law and it's not necessarily even a necessary component of the analysis. Here, procedural formality is defined in Mead as a relatively formal administrative procedure tending to foster the fairness and deliberation that should underlie a pronouncement of legal force. That's a very different kind of standard and one that does not necessarily refer to the Administrative Procedure Act. Now, a formal procedure or a formal adjudication conducted consistently with the APA might qualify, but the court actually identifies a number of adjudicatory schemes in Mead that are not formal in that sense and that nonetheless are formal for purposes of judicial deference. Now, under this standard, I think you can get a pretty clear yes to the answer of whether or not inter partes review proceedings are formal. It seems quite clear that through the very detailed procedures that are established in the AIA, that it's likely a court could say with substantial confidence that this is a relatively formal administrative procedure tending to foster fairness and deliberation that should underlie a pronouncement with legal force. So here I've given you 3 different ways that the law approaches the question of, is this a formal adjudication? And we've gotten the answers no, maybe, and yes. So what does this say about administrative law? Because I'm not so sure that it says anything about patent adjudication, although I'd be very interested if folks disagree with me. What this tells me is that there's little, if any, sort of cohesive idea of what formal adjudication is. And more particularly, that the Administrative Procedure Act is not necessarily the locus of how we would define formal adjudication. We tend to assume that it is, but in fact, the law suggests that that's not really how we're approaching this. The other thing is almost no adjudications are conducted under the APA or formally. We have a range of proceedings that, like those under the AIA, are very trial-like proceedings not conducted under the APA. And then there's a whole world of administrative adjudication that's largely unmapped, that doesn't even entail evidentiary hearings and that looks like something completely different. Now, you can contrast this with rulemaking. In administrative rulemaking, when someone says rulemaking, everyone knows that what we're talking about is the process that's established first and foremost by Section 553 of the APA, as interpreted by the courts, et cetera. But there's sort of a core procedural definition of what rulemaking is. And that just doesn't exist with respect to administrative adjudication. Now, many people have argued and have suggested, and including me, I'm already arguing against myself. I'm in my 3rd year of teaching, and I'm arguing against a published article. It's exciting. But a lot of people say the APA is a quasi-constitutional super statute. With respect to rulemaking, with respect maybe even to judicial review, that seems to be sound. But with respect to adjudication, it appears that the APA has utterly failed to create any kind of procedural uniformity, or even to give us a good touchstone for what constitutes formal adjudication, perhaps even what constitutes adjudication. And so I'm at a point in time where I don't have any prescriptions to offer, although I would like to identify some in a future version of the paper. And I hope that some of you perhaps can help me with my nihilism. I'll stop there.
So Jay, you're up next.
I've got a couple of slides, so. Great. Thank you, CPAP, for inviting me, and really enjoyed reading this paper. I learned a great deal from it, actually, because it's not the sort of thing that I spend a lot of time reading, so it was terrific. So, as you just mentioned, the research question that you're trying to answer is whether these PTAB, post-issuance proceedings, are in fact formal adjudications. You conclude that they're not, which is probably not that controversial. The second part, which basically, so therefore, where do you situate the PTAB with respect to other agencies? I think that's the more interesting question. And okay, sure. So I found the part of the paper where you're. So I'm an engineer. I'm used to sort of little diagrams like this. They make sense to me. So it doesn't make sense to you guys, then ignore it. But the idea here is that you're saying that if you look at section 554, 556, 557, then under those definitions, it's what you have under the PTAB is simply not formal. I don't think there's anything controversial there. And I, in fact, found none of those three conclusions as you move away from the APA and you start getting sort of different answers, and especially if you start looking at judicial deference under Chevron, you might even conclude that the answer is yes. That doesn't really I was fairly persuaded that that was correct. And I certainly understood the maybe being yes or no is fine as well. So you kind of come to the same conclusion that Walker and Wasserman make in their paper, and that sort of there's a little bit of overlap, not too much between and so we're now left with sort of asking sort of the Professor Asimov's sort of ABC, and because we have this oral hearing, we have this hearing, this evidentiary hearing, we're sort of in type B adjudication land, and that's also I don't think it's. I think you would get, broad consensus on that. That just leaves us with really, I think for a lot of people in the sort of patent world, asking, well, where exactly does the PTAB fit in with other agencies? And to me, that's a very interesting question. But I want to sort of take a little bit of objection to, and I've grabbed these 4 quotes from your paper about the PTAB, and I think you'll get a lot of people here in this room who might actually push back on this. Or you say, well, these are relatively formal procedures, so that they're substantially trial-like and detailed. Well, you know, and we'll talk a little bit more about this. And they grant parties substantial discovery, and that you actually have live witness and cross-examination of witnesses. I mean, these are. I think you'll see that if you talk to a lot of the practitioners of the room, they will tell you that is a lot of this is in fact not true. Okay, so you know, I flagged a few of them. You know, you can have a copy of the slides, So we sort of raises a couple of other things that I was interested in, and then I'll sort of you know, give you a couple of more points as well. But the first, there was a comment that you say that if the proceedings are formal, then courts are likely to give maximum deference. Now, is that really true? I haven't seen any work that sort of actually says that, you know, I just don't know if that's true as an empirical matter, that you actually get more deference if your procedures are more formal. I don't know if that's true. Maybe I'm not used to that literature, so it certainly raised the question in my mind, if that's certainly true. So now going back to asking about, in this world of quote-unquote exceptional adjudication, where do you fit the PTO? And if you go and look at, I mean, I didn't know that you worked in the administrative conference for the U.S. courts. In looking at this paper, I went back and I looked up those 31 best practices, including the 20 that Professor Asimov focuses on. And I was at least left with the distinct feeling that they were focusing on things that the PTAB and people who sort of work with the PTAB are not really that concerned about. You know, they're concerned about other things. And of course, part of the problem with that whole work is it's not designed for a academic to pick it up and run with it. Because you don't know where the underlying documents that they got some of this stuff from, what the coding was. There's sort of no real comments, so it's just very opaque. But I think that's a really interesting empirical project, which is really trying to, maybe even looking at 20 agencies that are somewhat close to the PTAB that deal with science and technology subjects and really start asking. And now you mentioned two problems in your paper. You said you talk about these APJs versus ALJs, and are APJs really ALJs? Great point. You also mentioned this, that there is no prohibition on ex parte communications. And those are points that are well taken. But let me give you a few others that the folks, you know, the PTAB are concerned about. Outside expert discovery, there is no discovery. And the only thing you get is you get an expert report and you get to depose the expert. That's all you get. You don't get to, even, for example, the Supreme Court has said secondary considerations have to be always looked at, but you don't get any secondary consideration evidence in at the PTAB. And then we've got the problem of insulation from judicial review that we've talked about. You know, there is, at least formally in the rules, there is no disqualification provision in the APJs, although I found out that there is over lunch that there is some mechanism for that. This morning we talked about the paucity of precedential opinions. I have no idea if that is in fact the case with some of these other agencies. And then we've got a situation where you have multiple petitions on the same underlying patent, which basically sort of raises questions of what is the role of precedent and finality. And you know, how does that play out? Now, Saurabh, Ardi, and I are doing some work on this issue, and let me just show you a little bit of data on this, and you'll see that in fact it's really quite interesting. If you look at all the petitions between the beginning, September 16th, 2012, to June 30th of 2016, a 4-year period, the actual number of subsequent petitions are more than the number of original petitions. So you actually have more repeat petitions than original petitions. And I mean, it's really interesting. In addition, there's all kinds of interesting issues about how, at least in a court, if you go and you challenge a patent, you basically may get an opinion on summary judgment, on validity, you know, grant or denial, and if there's a trial, you'll of course get a decision. But any subsequent judge that looks at that same patent is going to pay a lot of attention to the earlier opinion. But you know, that doesn't seem to be the case here. So in fact, just to give you just a brief summary of this, if you look at all the outcomes that are possible, including settlements, denial of institution, positive and negative final decisions, these are original petitions. And if you look at the subsequent petitions, typically, if your patent survives in a district court, then you basically have the chances of it surviving subsequently actually go up. Because one judge has looked at it, it's the exact opposite. That's what exact opposite happens. The institution rates go down, and the negative final decisions go up. So if you just take a real quick look at the two slides, you'll see that you know, the purple areas go down, the red areas go up. So to me, the second part of the paper, which is trying to situate the PTAB amongst all these type B adjudications, and trying to sort of figure out where they are and where's the center of gravity of this thing, especially for issues that the PTAB is concerned about, is, I think, you know, that's, you know, the cool part that I'd urge you to sort of look more into.
Thank you.
All right, so before I turn it over to the audience, I'm going to use my moderator's privilege to ask a few questions here. And my first one is going to be to Michael. So you focus on this very exceptional statutory section, 145, but that only really applies to examination coming out of the PTO. How would that impact if we had something similar for after a PTAB proceeding? So, you know, kind of building on the idea that there's private rights, there might be a way out of, you know, this administrative, you know, cloudiness of what that means if after a decision from the PTAB you could choose to go to district court for full de novo review versus the federal circuit.
The question had occurred to me, and my answer is I haven't thought it through because I don't know enough about patent law and patent law dynamics. Professor Rai had a wise comments on gold-plated or gold-plating patents are obviously very sort of pertinent in this connection. I'll have to think further about it and add it to the paper and maybe say a few things about it. And I'd welcome anybody, I mean, who actually knows this stuff to give me advice, suggestions. I'd be grateful. Sorry. Best I can do.
Adam, could I speak to that?
Yeah, of course.
So I think that was very much not something Congress wanted to do, because the point of the post-grant review is to have something that is reviewed at least relatively deferentially on fact-finding. So you don't, otherwise, I think, as I mentioned in my comments, you don't get any efficiency gains if it's all subject to be fully open again in the courts. So, you know, certainly the economic case for post-grant review was premised on the idea that the decision-making wasn't subject to being totally opened up again.
Certainly makes sense to me. And then what I wanted to ask Emily is, and to Jay as well, is to what extent the choice of how one answers your question, like you provide three different ways that provide three different answers. And I think about this from a almost quantum mechanics, Schrodinger's cat situation where the answer is unknown. You know, what happens if we answer the question using, say, the agency procedural discretion model versus the deference model?
What do you mean what happened?
Like, does choosing one way of answering the question result in different outcomes for how, say, litigants are going to be appealing? You know, is there going to be more or less deference? Is it always going to be Chevron, something less?
Well, and so, and I guess one of the difficulties here is that one of the questions you might ask is what do we want the consequences to be? Right? In theory, the reason why the APA has adjudication provisions is because we wanted to establish a certain baseline of procedures that anytime an agency's doing adjudication, these procedural minimums have to be met. And I think the one thing that, and maybe the key thing that comes away from the analysis is that that has just failed. And I'm not the first person to sort of acknowledge this, but the APA has not succeeded in establishing a uniform expectation of procedural minimums in adjudication. And that strikes me as a problem, which, and we were talking about this at lunch. Some would say it's a feature, not a bug, because so many, so many agencies and so many determinations that have to be made are different. I'm inclined to think it would be good if we had some agreement on some minimum procedures that at least in some category of adjudications, which it strikes me that this is the kind of adjudication you would want to have some kind of procedural floor. We want to have an agreement on what those minimums are, because it's very difficult from an administrative law perspective to critique this procedure because there isn't uniformity or really sort of enforceable compromise about what adjudication should look like. And part of that, by the way, is that it's not just that the courts haven't come up with a good test, it's that Congress routinely makes brand new, out of whole cloth, totally distinct procedures for different kinds of adjudications. Now, the answer, if you could say this is formal, what you would like to be able to have that mean is that there's some set of procedural minimums that the agency has to comply with, regardless of subject matter. And unfortunately, the law is such that that's just not, it's something we don't really have.
I agree with what you're saying, but there's a couple of points that I think in response to David's question. One is, is it possible to at least think about this as a birds of a feather kind of situation, where at least some agencies that are sort of somewhat similar, both in terms of the number of cases they deal with every year versus the stakes. And so you sort of have, basically, you have different procedures, but and that's understandable. If you're dealing with 50, 100,000 cases a year, then you may have something different, and the stakes may be small amounts. You certainly don't want the procedures to be to cost more than what's at stake. So that's understandable. But here in the PTAB, we're talking about, say, 2,000. Roughly, I think we're running at about 150, 160 every month. That's the rate that we're running at. It's worth asking, what are the peers, to the extent that there are peers, and sort of a birds of a feather, where does the PTAB fit? So I think it's the fact that you sort of don't have, the APA has not delivered on an adjudication baseline that everybody can sign on to, that doesn't necessarily bother me. As much as what bothers me is that, like agencies, are they in fact following similar things? To the extent that they have the same kinds of cases by numbers or with stakes, are they sort of somewhat similar, and is there some best practices emerging?
Actually, that's a good question. Just, as somebody who's a patent law person, I have no sense of what the other agencies are doing. I was wondering if either any of our admin people on the panel could comment on what might be a closest agency to look at, particularly in the context of how one determines how formal it is.
So the administrative conference just completed this study of, I think it's over 100 agencies. And there's literally hundreds of Type B adjudication programs. And the thing is, they're all different. So I was working at ACUS when the research on this was going on. And I was not super involved in it. And I probably could have inserted myself, but it was such a painful process that there were many reasons not to. Because just finding that information is extraordinarily difficult. And one of the reasons why adjudication looks the way it does is because the programs are so different. I hear what you're saying, and I think it's a good way to analyze it. But at the same time, there's just so many different birds. They're hard to catch.
All right, I think I can turn out to the audience now. Who all has questions? Got Stuart and Melissa. And as before, please wait for the microphone.
I shall.
Alex is coming around. He'll be there from behind. Oh, we just have one this time, so it might be a little.
That's all right. So, Stu Graham, Georgia Tech. So I wanted to talk a little bit about the numbers here. Since we've been talking about the numbers, Jay Keeson just pointed out that we're running at what, an equilibrium, or a sort of 1,500, 2,000, something like that on an annual basis.
Yeah, about 2,000.
So this reminds me of something Rob Stern said on lunch. That people have been sort of surprised that the numbers have been as high as they have been. To those of us, thanks Artie for mentioning several of the people who worked in this area, along with Dietmar Harhoff and others. That actually it's somewhat shockingly low. If you, for instance, if you look at the European Patent Office opposition system, which is much more like the post-grant review that's going to be coming online as more and more patents are granted, something on the order of 5 to 6% of all patents are being reviewed. And if that's an appropriate benchmark, there are reasons why it might be too high. That benchmark applied to the 300,000 patents that are utility patents that are issued every year is something on the order of
15,000.
15,000. Yeah, exactly. 15, 20,000. So this could be indeed this could be an added reason why we got to make sure that we get it right in the early running. Also, though, it's not shockingly surprising to those of us who've looked at the data either that many of the same cases are showing up in both procedures. So when we looked at the original data in U.S. litigation and European Patent Office opposition, now granted they're in different jurisdictions, et cetera, but the shares that we were getting were about 20%. So if we extrapolate that to 3,000 cases a year of in the courts, then that would be something on the order of 600 cases just there. So there are lots of good reasons why that might not be the case, but it's certainly worth considering that we may just be seeing the tip of an emerging iceberg.
Any comments?
Just two comments, Stuart. Those points are terrific. I think, though, we're really comparing apples and oranges because the European opposition, at least my knowledge of it and what I experienced when I was in private practice, is it's much more of a super examination. It is much more along those lines. The judges will go back, they will amend the claims and come back and offer you the amendment right then and there. So it's a very different process. And it tends to be substantial. Right.
Because there's no and national.
Right. And it's substantially cheaper as well. In our work, Saurabh, Artie, and I showed that about 87% of all of the PTAB petitions have corresponding litigations in federal court. That's what drives us in our system. And our system, even if you do it as cheaply as possible with attorneys and everything, we're talking about $150,000, $200,000, which is considerably more than what it costs in Europe. So I think costs are playing a big part of it, and it's also we're sort of operating as within this sort of assumption, which was made even when the AIA was formulated, that this was supposed to be a low-cost replacement for validity in district court, and the sort of the substitution argument.
Artie, did you want to say anything? Can you still hear us there, Artie?
I apologize. Yeah, so I think there's a larger point here, and that is that proceedings in other countries don't always translate perfectly to the U.S. litigation context. I do remember that talking to Ed Rubin, who is one of my administrative law mentors, way back when about this. And he said, you know, in the United States, we're just so much more litigious than the Europeans. And so we will probably make a hash of this in a way that the Europeans just wouldn't. Of course, I've made the point that we also litigate, US lawyers also litigate in Europe. But yeah, I mean, I think that there's a lot of, there have been a lot of unexpected, events that have arisen. I am, at the end of the day, less pessimistic, I think, than perhaps Jay is, that I think we can work through them, and I think we will work through them. And I do think that part of the problem as well is that district courts are so uneven in their decisions to stay litigation, and I think they should do a better job in kind of figuring that out. So, yeah, so that's a general comment.
Do you mind if I just have one tiny thing to say? So one other thing I want to say, and this is dovetailing on Artie's comment, the one thing that I think is relatively uncontroversial is that as the costs associated with the administrative review rise, the potential benefits to society, those sort of the welfare benefits, erode very, very quickly. And so if you don't keep this thing relatively cheap, and I'm not talking about the price, I'm talking about the overall cost, all in, then we start to lose any potential benefit.
I know Melissa had her hand up if she still had a question, but Alex, with Artie, we need to make sure we get everybody on the microphone.
So my question's really for Emily. So I really liked your paper, and I like the framework that you're thinking about. When we use the term formal adjudication, we really could be talking about one of these three different things. But I would push or encourage you to engage more, because you know that there's a debate in patent law literature about whether PTAB is formal like adjudication to get Chevron, and I would just push you to engage with that literature more. Because when I read through it, I've written on that topic, Artie has, John Golden has, and it was unclear to me how much your analysis differed in the sort of Chevron from what's been written, and sort of, I kind of saw my analysis as spanning your second and third category. So I did, and one thing I think that could be helpful is if you could impart, maybe put us in the boxes, or is that part of what's driving the difference between John Golden's sort of analysis, where he's come out the opposite way, I think, than what Artie and I have argued? And then second, I was sort of curious if the difference between your first category and your middle category at all had to do with the circuit split on whether you have to have both hearing and the magic words on the record. Because when I think of your discretionary procedure to agency, I almost think of that as the DC Circuit type of, well, we'll give you Chevron to the determination of whether, if it has hearing only, you need to do formal or you want to do informal.
Yeah, so those points are very well taken. Knowing that there was this literature, I decided to first look at the case law myself and try to do an independent analysis, because I didn't want to just be too overly influenced by the other many voices that are out there. And this is sort of what I was getting at in the notes of the paper, because it's an early stage draft. I've read that now, but I haven't totally incorporated it. And I will say that, the way that I am understanding and breaking out what I think the law is doing is not the same as what other scholars have done. And I think that's in part not because we all disagree, but because the law is so fractured that I think there are different ways to break it out. And that's something that I need to address, and that I will address in a future version of the paper. I'm not sure if that is, I think I'll just stop there. Can I ask a question?
Of course.
So I guess one question I would have, in some of the other discussions at lunch and on the other panels have raised this, is, I did this analysis looking at the statute and the regulations that PTO has adopted. And the impression that I am getting is that, to the extent that there might be pushback on how I'm interpreting that statute and those procedures, is it sounds like what has happened is that there's a deviation between what the law says and establishes and what the PTO is actually doing. And I just want to make sure that I'm understanding that.
I mean, I would speak from my own experience and say yes, but anybody else can, of course, chime in as well.
Well, that got some hands.
So don't have an answer to that question, but
Sarah Vishnabak, Texas A&M. So one good place, I think the answer to that is yes. I think a good place to start for what the agency's held positions are and how they change over time. And this is something I relied on quite a bit for the portion of my paper that dealt with panel stacking, is the briefs that the solicitor, the USPTO solicitor, files in Federal Circuit cases. Even the ones that don't go to en banc reconsideration, just the three Federal Circuit judge panels, those briefs reflect a pretty good contemporaneous account of what the agency's revealed preferences are. And particular, and this is a little tougher to cite perhaps, but I found a way in my draft, the oral argument recordings, where they actually talk about in a sort of colloquy between the judges and the judge on the Federal Circuit and the solicitor's office, they will say, here's what we are really getting at. That's where those revelations of panel stacking came from, is in the oral argument itself. A judge pushed an associate solicitor, and the solicitor said, yes, here's what we do, and here's why we do it. That may or may not hold water over time, but that's where we sort of could find what the agency's revealed positions are.
Unfortunately, a lot of what happens is buried in the proceedings of individual petitions and their consequences. Mm-hmm. So, in one case, the panel read out of the claim elements, and then proceeded on the truncated claim, so to speak, to find that it was obvious under 103. And had they left the elements in that are plain language, it's right there, it says this, the claims might have survived. And so I think looking at this at a high level is very useful, and the statistics that Lex Machina and others have collected and scholars have collected are suggestive, but a lot of the details of how the PTAB, in particular cases, reasons to the conclusion that they want, which is to kill the patent, is buried in there.
Josh?
So for my question, does the formality matter? And I'll ignore the Chevron deference or not issue. Judicial review of fact, 706A, arbitrary and capricious, 7062E, substantial evidence. Guard side says substantial evidence for these things. Not clear that A, they're right, and it's not clear that it matters. And then 7062F, unwarranted by the facts, to the extent you have 145 de novo review. What does that mean? This is the real question. Does it matter how you phrase the terminology for purposes of judicial review of fact? If so, then this stuff matters. If not, who cares?
Does anybody here have a comment on that? Emily, Artie?
Yeah, so Josh, I think the other reason it might matter, although realistically it seems like the Federal Circuit is going to perhaps refuse to apply Chevron no matter how formal-like or resembling the kind of proceedings Mead was thinking of. The reason it matters is, are we going to get Chevron deference to anything that's done in an adjudicatory proceeding? And that's what Aqua Products split 7 different ways over.
I mean, I know very little about patent review, but my general impression from administrative law is that it's somewhat misleading to put too much into the precise standards, right? So Gary Lawson plays music for his students to explain what the standards mean, right? So hard look review is Twisted Sister. We're not going to take it. I don't know what he does for substantial evidence, but I would be, I mean, barring some empirics, I'd be a little nervous about this. And mind you, I mean, if you look back at Dickinson for Zirko, right, where you have a lot of, high-level argument mobilized for something that, at the end of the day, may not make a big difference in practice.
Any other questions out there? Devlin?
Hi, thanks so much for doing the panel. I've really been enjoying it. So my question is about oil states, because I've got oil states on the mind. And I'm wondering, I'm an IP guy. I understand property law. I get the difference between private property and public property, and I have zero doubt that patents are private property. But then I understand in the oil states case, that's not necessarily the issue. The issue there is public rights versus private rights. And so I'm having trouble understanding how that interacts with property. And I'm wondering if you could weigh in and I'm just curious what you think about whether patents are public rights or private rights, and potentially why you think that. So put you on the spot if you don't mind.
Yeah, I think I'll start down at the end with this one and work our way back here.
Good grief.
Oh, you volunteered.
I
so
don't want to
that's
go
why you
anywhere
first.
near that. The paper has a brief discussion about it, and I think it's pretty safe to say that under the case law that is out there, there is no problem in subjecting patents to administrative adjudication. There are a lot of more specific questions that may arise over the review and re-examination system we have, so pre-existing patents subject to sort of novel procedures, that sort of thing, right? But in principle, I don't think there's any constitutional obstacle at all to subjecting patents to administrative adjudication in the first instance. At least not under the case law. Whether that's a good thing or a bad thing is a totally different question. So I was actually struck that Professor Rai thinks this case may be sort of closer than I think it's going to be. We're sort of fighting with reverse fronts here, maybe.
Artie, your nameplate's next, so I'll turn to you if you want to comment.
Sure. Yeah, I didn't mean that the case was going to be close necessarily as a matter of my interpretation of 20th century case law. However, there may be those who don't think 20th century case law on these issues is legitimate. And so if you don't believe that 20th century case law on these issues is legitimate, then perhaps you will not agree with, and I filed a brief in support of the respondent's position. Perhaps you will not agree with the arguments that Greg Riley and Mark Lemley and I made in that brief.
Emily or Jay, do you want to weigh in on this? I know, Emily, you may not. That's patents.
Yeah, I will leave that to folks more educated than I.
Well, November 27th, we'll find out.
The article that Professor Wright just mentioned, Greg Riley's, is the most sort of extensive discussion that I'm aware of that's out there in the law review literature.
So as the runner, I have a question, particularly for Professors Brenner and Keeson. There's been a lot of discussion today that there seems to be issues between what administrative law says versus what the PTAB and the PTO are actually implementing, but I'm curious if in your research you saw any other issues that the other administrative body at the PTO, namely, is there something endemically wrong in the implementation of administrative law in front of the PTAB also, or is this really a failure to mix administrative law and patent law, or is there something endemic to the segment of the administration here?
I mean, so I have not looked at the PTAB. I mean, I was really just focused on PTAB, and I mean, from my perspective, it seems that Congress has created a patent-specific administrative procedure. I saw no indication in the statute, no indication in the legislative history that they were even thinking about the Administrative Procedure Act. There are some references about how it's going to be a trial-like or a court-like proceeding. There's a reference or two to how we're going to make this adjudicative. There's no indication that they're thinking about that from an APA perspective or even from an administrative perspective. In fact, to the contrary, what it seems like is we're trying to create a cheaper, more efficient, faster route alternative to district court litigation. So how can we make a procedure that looks like district court but takes place in an administrative tribunal? And so from that perspective, administrative law is sort of wholly absent from the analysis.
I would agree.
Okay. Well, if there's no more questions out of the audience, I have one that kind of picks up on something Artie asked in her commentary originally, I know Stuart mentioned, which is sort of the ongoing economics that kind of motivate some of the choices that have been made. So, Artie mentioned the economic history. Stuart mentioned that these procedures are becoming more expensive to actually run through them. Is there any concern that a lot of the potential solutions to any of the problems that are addressed seem to be more procedure and therefore things that will become more expensive, whether it is replacing the PTAB entirely via oil states and moving everything to district court, or giving more procedure to participants in front of PTAB proceedings? I was wondering if you could think of ways that might go the other direction, ways that would make this process cheaper and respect kind of the economic rationale that motivated the creation of the PTAB in the first place.
So I will say it's not clear to me that more procedure in this context would necessarily be more expensive. I mean, if the problem here is that there's not a real adherence to the procedures established in the statute, and there's a bias in favor of, finding patent, in canceling and invalidating patents, then that might be incentivizing people to use the PTAB procedures, because they're not following the procedures established by statute and because they're very inclined to cancel patents. If you adhere to the statute and you eliminate the bias in favor of canceling patents, maybe people will file fewer petitions. I mean, and I say that as a patent outsider, but I sometimes wonder if it's necessarily always the case that more procedure is more expensive. It depends on how people react to the new or greater adherence to procedure.
Okay. Sarah?
So a comment and a question on the issue of the substitution hypothesis, which, as Jay mentioned, our paper, Artie's and his and mine, looked at. It's well to be clear that certainly anything that already was in district court being sent to the PTAB as a substitute would indeed, the Congress intended for that to be a stand-in, a cheaper alternative. But Congress also, in creating the PTAB and the AIA proceedings, removed any requirement of standing. And so people who are coming into the PTAB, there's at least some substantial group of them who would never have been able to go in the first instance to court. And that was very much by design. It was intended that we wanted to increase the number of people who could challenge, to broaden beyond just the people who wanted to practice the invention themselves, right? Now, this is widely criticized as a policy matter. We don't want people who have, quote, no stake in the patent. But how we define a stake is something that Congress weighed in on. And we can agree or disagree, but Congress did do that. So if we're talking about the system overall being less costly, we surely have to take into account that they tried to cut down costs over here, but did something on the other end that would increase costs. And then we have to, it's an empirical question whether the total cost outweighs the total benefit. So just food for thought. And then my question, with all this discussion regarding whether the APA creates adequate minimum procedures, adequate minimum safeguards, when I was taking administrative law, and it was at a school that's much more known for patent law than for administrative law, I went to Franklin Pierce. So maybe that sort of informed my education, but I always learned the APA is basically a set of default rules. And if Congress wants to step in and say, well, we don't need those default rules, we have a pretty clear sense of what we want to accomplish in this area, be it patents or securities or tax or whatever, completely free to do that. If you take that much more default rule transactional, if there's a gap, the APA will fill it. But as time has gone on and the administrative state has become much more responsive politically to interest groups who say, we want to accommodate all of these eventualities, the need for gap filling by the APA perhaps has become less salient. And so it doesn't function as it needs to as a default gap filler because there are fewer gaps to fill. That says nothing about minimum substantive or procedural requirements. So I was wondering what your thoughts might be as a panel on that.
So I would say that I don't think the APA's adjudication provisions have really ever operated that way, because if there's a gap, the APA, the provisions only apply if Congress is very specific that they apply. And in the absence of either a reference to the APA, like direct cross-reference, or the magical language, hearing on the record, the courts have said, oh, there's a gap, agency, feel free to fill it however you choose. So I just don't think that the APA adjudication provisions fit that way. There's also, I'm not sure I agree that that's what they were intended to do. My understanding is that a big part of the reason for the APA's adjudication provisions was to establish uniform minimum procedures across agency adjudications. And it also just never succeeded in that at all, as far as I can tell.
Artie, or how's that time if you want to have one last comment there?
So I wanted to go back to the point about the economics, because I tend to be obsessed with economics. And I do think that, I think it was Emily who pointed out that more procedure won't necessarily lead to more cost. I think that's a little bit perhaps inaccurate in the following sense. Yes, it may lead to fewer challenges, but per challenge, more procedure, presumably, unless we can have very expedited and streamlined procedures, typically does lead to more cost. Now, so there's a difference between cost per challenge and overall costs, which I think Sarab also picked up on by noting that the AIA explicitly encourages more challenges by eliminating the standing requirement. So one has to think of costs in all sorts of different ways. So cost per challenge, overall costs of the AIA system, and then, and hardest to measure of all, because this is all not public information, the costs of licensing patents that may be invalid or, well, for purposes of the AIA, invalid, which was the cost that it appears Congress was most concerned about, because it thought that in the shadow of the cost of challenging patents in court, one would incur wasteful expenditures in licensing invalid patents. So we have to be very careful when we talk about costs and what exactly we mean.
All right. Well, with that, we are out of time with this panel. Thank you very much. I think, let me check. Yes, we have a little break before panel 3.